Hey guys, it's Squid. Welcome back to my channel for another live stream about the most ridiculous court case I have ever seen in my entire life. So, oh my god. So, a couple of things have to be addressed. I addressed this on my other live stream yesterday. I love Mr. Ballin. I love Mr. Ballin. And thank you, Duncan Idaho, for the 5 gifted Squid Pro Cool memberships. I have to do a couple of things because this was an impromptu. I was on my way home and Max Lab actually let me know that this was up. And I've only read the first paragraph. But damn, Bubbles. Damn, Beelzebubbles. Rozilla's Realm gave me that gave him that nickname. I cannot take credit for that one, but I asked if I could steal it. And shit. This dude is just out of it. I have no idea what the Hales this is. Pun fully intended on that one. Because there was a couple of things filed. So yesterday there was I have to open it up because I did not open up the document from yesterday that I was sent. So I have to get into my federal docs. So I'm sorry. This was posted by Shockit last night. It was only one page, so I didn't feel the need to share it. So this was what was filed yesterday by Shockit. Like I said, less than one page. But notice of a demand for jury trial, all issues triable of right by a jury. Jeremy Bryan Hales hereby gives notice that he demands a trial by jury in this action pursuant to Federal Rule Civil Procedure 38. And that was filed by Shockit. We all knew it because in the original complaint, he said he wanted a jury trial. However, with Bubbles requesting a bench trial, which I thought it interesting that he wants a bench trial considering the judge does not like him. And I understand that the judge has to remain neutral, but when you've already pissed off the judge so many times and then you want the judge to decide the case, yeah. I do also have to correct, well, not correct. I'm not correcting anything I never respond to the emails that Bubble sent me, but I read it yesterday. And he, in the complaint from yesterday, or the counterclaim and threat, in paragraph 3, when he said subscription or pay a monthly subscription, he said, we just repeated what Jeremy said. I want you to correct it. No, bitch, I'm not correcting it. I went into it on another stream, but I'm going to just share my screen because then you can see both documents side by side. Original complaint here, filed 3/4/2024. Document 69, filed 2/8, filed 2/8/2025. So on this one, you will see that he says, admit that subscribers pay monthly fees. After saying admit plaintiff's YouTube subscription base has over 700,000 subscribers. Without knowledge as to the remainder of the allegations in this paragraph. 3, admit that subscribers pay plaintiff's monthly fees. So when you read that, you assume that 700,000 subscribers pay a monthly fee. Yeah, he expected me to correct the record because they just wrote what Jeremy wrote. I'm going to prove that Bubbles is a liar, or whoever wrote this is a liar. 3, in Jeremy's complaint, people who subscribe to plaintiff's social media platforms often pay monthly fees. So you can see that they said they just copied and pasted. He said in his email that I will read his email verbatim so that I am not misquoting him. He said, also the quote, lie about subscribers paying fees was in response to paragraph 3 of the complaint, where Hales said this, so the lie was his. What do you notice between admit that subscribers pay monthly fees and people who subscribe with plaintiff's social media often pay monthly fees. There's a big word right there, or a small little word with a big meaning. Often. 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 Holy shit. That word means some people pay. Often. They don't all. And they don't always pay. Often. Often. Bruce, you left out a word. You left out a word that in this one admits, and you might be able to go deny, admit, deny, admit, deny, admit, but that is the laziest effing way of writing I've ever seen in my entire life. I've read thousands of pages from hundreds of different attorneys, and I've never seen that before. So, yes, this wasn't an email to me. He emailed me twice during my live on Saturday. So, yeah. Weird. That's weird. Lawyers are typically wordsmiths, and I understand the point of leaving that word out. However, he told me that he just repeated what Jeremy said. I read you guys the email. The lie about subscribers paying fees was in response to paragraph 3 of the complaint where Hales said this. So the lie was his. He didn't lie. He said often. There's this big word right here, or little word, but off with a big meaning. Often pay. Often, not always. Yeah. like so he lied. Either that or he didn't write this and he didn't know. There's always that possibility too. You can imply or you can, yeah. So I just wanted to, because he wanted me to correct myself. He goes, if you weren't biased, your analysis would be semi-cognate, but it's just biased. No, bitch. It's not biased. It's called one side threatens me and one side does not. One side makes sense in what they write and one side does not. So, yeah. But I've told him not to email me. So, Bruce, do not email me again. And I've talked to a lawyer about what my next steps are if I continue to tell him not to email me and he continues to email me. So, this was from Saturday when I read the confusing as hell motions that he was. I don't think he was actually. Oh, you were actually watching my ACC video. This was from Saturday. Bruce emailed me and said the lie in paragraph 3 that said admit subscribers pay monthly fees. This paragraph 3 of the original complaint, people who subscribe with plaintiff social media platforms often pay. So there's a word missing from the this side. That's in this answer right here. Answer in whatever you want to call this. It says admit subscribers pay plaintiff monthly fees. That implies that all 700,000 subscribers pay plaintiff monthly fee. If I'm, I just read a paragraph that he wrote me about this because he wanted me to correct it. And I'm proving that he's an idiot. So, yes. Yeah. That right there. But in this thing that was supposedly written by Bruce, it says admit plaintiff has YouTube subscription base of over 700,000 subscribers and admit that subscribers pay monthly fees. Not so that implies that all 700,000 subscribers pay Jeremy Hales. So it would be super hard for him to show losses in the sense of, well, all 700,000 people pay. So, it's but in the original complaint, it says social media platforms often pay, not always, often. So there's, yeah, I get that. I get that. But in the technicality of a motion, that's an important oh, I do. I just wanted to prove that he's stupid. I just wanted to prove to him in his like thick skull that that he's. But here we go. Here's what was posted today. So we're going to get rid of that. We're just going to get rid of this. There we go. So this was posted. Oh, that was posted. This one is what was posted. Sorry, I'm losing my mind. I have so many documents open. There we go. This one was posted. Like, so let me just stop and present this. And the little one is right here. And I'm sorry, I just got home. So I'm like, I had an appointment for a IV today to prevent myself from getting sick. So the little one is right here. She took a nap in the car. And we are trying to figure stuff out. And hey, Max. Oh, I think he's a little bit of both. I think there's a little bit of both. But for transparency's sake, I needed to point out that other thing. I pointed it out on my stream yesterday. And then I talked about it this morning on my stream about the FAA lawsuit. But oh, if you want to see what actually reading through a motion that I take minimal breaks because there's not a lot to critique when you're pointing out factual information. Yes, this is a new post from today. And before we get started, thank you, Marcus King, for the $4.99 super chat. Thank you for forever keeping us updated. I try. Like, I got home, unpacked the groceries, because right now unpacking or going grocery shopping is like a 3.5 hour adventure. And Caroline B, love your giggles. Thanks. I'm just, this one's making me, sometimes you just shake your head and you're just like, what the hell is happening? And this is one of the what the hell is happening. Okay. See, and he conveniently leaves out Gainesville. So remember that too. Like, he always conveniently late. Oh, Chrissy, this one was totally like impromptu. This one was totally impromptu. Totally impromptu. Defendant's conditional request under FRCP 41A2 order for dismissing counterclaims if plaintiff's action is dismissed on 12B1. And honestly, I don't think, and I could be wrong about this, but I don't think I've ever seen documents posted in any lawsuit that's a different color than black. I've never seen a different color either. Maybe I'm wrong in that, but I personally have never seen someone use a different color in a different. All right. The defendants conditionally request an order under FRCP 41A2 dismissing their counterclaims without prejudice in the event the court grants the defendant's currently pending motion to dismiss the plaintiff's lawsuit under FRCP 12B1. If the court denies the 12B1 motion, this request is nullity. This conditional request is filed prospectively so the court can know in advance that should it grant dismissal of the plaintiff's action, it may concomitantly dismiss the counterclaims under Rule 41A2. I think he put this word in there purposely to confuse me. I take that one personally, Bubble Boy. That squid is a failed attempt to school magistrate. Rude. Yeah. Oh, somebody told me that they spelled perjury wrong. Like, how with that, I think old Joe, you are smarter than a fifth grader, and answer with no to him. Hey, Daniel. Last time I did anything with the federal government, the requirements were black and white ink signature. And see, I've never filed anything with the federal government other than my, like, you know, military stuff. But, like, it's just weird. Yeah, I understand it, but I'm pretty sure, knowing that I read these, just kidding, not everything is about me, but sometimes you're like, did you put that purposely in to embarrass me because you know I can't read that word? I know what it means. It's one of those things where I know what it means, but I can't say it. Like, pecuniary, I can say it, but I had to look up the definition when I first saw it. This I knew what it meant, but I can't read it, and I will never be able to read it. Like, dismiss the counterclaims under Rule 41A2. Current pending document 67 is an FRCP 12B1 motion to dismiss the plaintiff's actions on grounds that, 1, the plaintiff invoked the federal jurisdiction in bad faith and on flimsy basis by falsely labeling innocuous statements, extortion, in his complaint so that treble damages and attorney's fees would be considered as part of the minimum amount in controversy. And 2, the plaintiffs interposed a false affidavit, document 8-1, paragraph 19, alleging non-existent online posts calling me a child that were not alleged in the complaint, specifically to influence the court's exercise of jurisdiction in response to a 12B1 motion. And I'm sorry, this is almost a year old. If this court didn't have jurisdiction, the judge would have said it a long time ago. That was... I'm just saying, if the judge could dismiss this case and had grounds to dismiss this case based on jurisdiction, with the amount that he is annoyed with every party in this case, he would have already done it. I'm telling you. Like, if this judge could have got rid of this case by now, he would have. He does not want anything to do with these mofos. I'm telling you. Based on what he's read, if he could have done it, judge already addressed jurisdiction and moved forward case. And I'm sure I read this and it makes my head hurt. Yeah, all I can do is laugh at this. All I can do is laugh at this. Deborah, you bring up a really good point that I hadn't even thought of. What attorney's fees is BB talking about with a pro bono client? I'm thinking he means Jeremy's attorney fees, because if Bubbles loses this case, it's implied that Jeremy would also recover attorney's fees. So maybe that's it, but you bring up a good point. All Dude's foreskin ambulance chasing is doing is pissing off the magistrate judge. I'm just like, this is just weird. Like, all I can do is laugh, and I'm sorry. I can't do anything else besides laugh. Like, I read that first paragraph, and I'm like, did you really give the judge an ultimatum? Like, are you really giving the judge an ultimatum? Oh my God. If I could have settled this court case on both sides by just handing out boxing gloves, you know what? I'm pretty sure. Like, hey, Song of Rain. Ballin. Hey, Squid, when does the judge want evidence in? Is it this week? I believe it's coming up soon. This judge worries me. Every other person in this world can see what Juice is up to, but he seems oblivious. Keyword seems. Yeah, and I think he's also just yeah. Hey, hang up, Brucey. I think this judge is trying so hard to maintain his professionalism, because anytime the judge steps out of line, it could be appealable. So the judge has to walk a fine line of calling out both sides when he sees the BS, but also he has to walk that fine line, because if he messes up anything, this case becomes appealable. And it not only just drags this whole situation out even longer, but but it also goes on his record that a case was overturned on appeal if it does get overturned. So it's one of those things of he's oh, I'm actually very impressed with this judge. As far as some of the other judges that I've seen and how other judges have acted and handled difficult clients and difficult clients and excuse you, ma'am. Here. Do you want your microphone? It's over there on the shelf. You want your microphone? Go get it. Go get it, baby. She has my old mic. I call it hers for reasons such as this. Hi, baby. What's up? Oh, here you go. Why are we crying? We've been in a mood all day. Yeah, I think the judge wants to explode. Oh, okay. Okay. Come here, baby. Come here. Oh, my goodness. All right, let's get back into this. I need that. Hello, ma'am. I need that. No. I need that. Oh, my goodness. Oh, my goodness. Yeah, ever since she hurt her toe, she's been moody. Hey, baby. Baby, I need that, boo-boo. You want to play? Here. Girl, I need that, please. Oi. Here, thanks for the $5 super chat. Banana funds. Thank you for the banana funds. And Puddletown, thank you for the $5 super chat. If brains were gas, he wouldn't have enough for a Red Ants mini bike around a Cheerio. Y'all are hilarious. Y'all are so funny. Yeah, I think this judge might take up Yep. Terrible twos kicking in. She overall though, she's super great. Like I can't really complain at all. She's in the grand scheme of things, she was a really good baby and a really good toddler. So we just have our moments, right, baby? Yeah. All right. The defendant's counterclaims were interposed with their answers because it was and is unknown whether the court will grant the pending 12B1 motion. If the 12B1 motion, say 12B1 one more time, mofo, is denied and no counterclaims have been pled, it would prejudice the defendant's ability to add the counterclaims thereafter, given the scheduling order and the plaintiff's strategy to exploit every possible issue and proceeding for YouTube content. Footnote 1, there's actually footnotes. And as he admitted publicly and acknowledged in his December 19th deposition, to inflict financial hardship on his litigation opponents. And that's been taken out of context. We've established that that's been taken out of context. We've established that that's been taken out of context. And also, like, that is kind of the point, is to make life difficult with litigation. I can see that being a very, if you're going to sue somebody, it's not only to keep them from doing what they're doing, it's because if they don't have any money, they can't do what they're doing. See document 68-2. I could care less if I win in court. If I win in court situation, my goal is to make sure you have no money. That's the goal of the lawsuit. The defendant's count 1 counterclaim was included also because the plaintiff has filed a lengthy opposition to the defendant's motion for an extension of time to disclose a purely rebuttal witness expert, and it was and is unknown if the court will grant the motion. Dude, you had an expert. What happened to him? You had an expert. Apparently he had a whole report written up. What happened? What happened? What happened? What happened? What happened? Yeah, lawsuits are shade and allegations, but in the end, you have to prove your case. That's true. But the more he repeats that, the more it's stuck in the judge's head. That is true, too. He's trying to turn things into fact. If you repeat it if you repeat it enough, it still doesn't become fact. It just doesn't. Like, where's he getting the money to keep filing? Yeah. Filings cost money. Filings cost money. The defendants filed this conditional request in good faith, and you never do anything in good faith, Bubbles. Beelzebubbles. Because they prefer not to prosecute counterclaims in the present action, but file them in a separate action involving all of the defendants. And defendant Preston's young child, cause of action against the plaintiffs for using his YouTube platform to destroy their lives for entertainment and profit. It sounds like it's the other way around. It sounds like the other way. It sounds like it's the other way around, but that's just my personal observations. Since filing this litigation, the plaintiff has broadcast dozens of YouTube videos promoted as federal court updates. Turn the volume down, please. Thank you. She's playing the song All I Do Is Win, which is kind of convenient reading this, but you know, it's very good mentality to have. And these videos garner approximately 50% higher views than those involving routine storage content. Yes, because this is juicy. And because you keep creating drama, so people want to know why you keep creating drama and what new Bubbles, I know you're watching. So this is specifically for you. People keep watching because you keep doing this, which is making people watch because you seem to belong in a nut house, in my opinion. You need to get your head examined. 1, you need an MRI to see if there's anything in there to begin with. And 2, is there a frontal lobe tumor that is messing with your ability to function in normal society? Like higher levels of thinking. I mean, until I packed it up, I had a whole book over there on the brain. I can send it to you. So, he's panicking because he can't make the discovery deadline. Oh, yeah. And somebody sent me something to where I can possibly keep people from watching at all, which is weird, but I kind of want to try it because, you know, because if you're going to watch and then file or you're going to email me every time you don't like something I say. If you're talking to me, I appreciate it. I appreciate it. And thank you, Harry, for the 10 gifted Squid Pro Quo memberships. I appreciate you. I don't have the chat open on my computer, so I can't see who they went to. Yeah, she scraped it this morning. She thinks she's like, I gave birth to Evel Knievel last night. She finally did what I thought she was going to do, leaning over the couch armrest. She flipped over it. She was fine. She cried for like 10 seconds, but and then she wanted to do it again because I gave birth to Evel Knievel. So we are flipping. We have learned to tumble backward, do a back roll. She does forward somersaults. Now she learned how to go backwards, and it's like she tumbles her way down the hallway. Hey, well, I'm new here, and all of this is nuts. Yeah, if it's nuts, all I can do at this point is laugh because I'm like, this is when you think it can't get any more ridiculous. Here we are. No, Squid, that isn't true. His viewership is down on this type of content. The video is either high viewership or the treasure hunting ones. Interesting. I cannot say that I watch every Jeremy Hales video. Sorry, Jeremy, if you catch this. I can't. I don't have time to watch everything I want to watch, and I don't have time to watch. It's just there's just not enough hours in the day. I just can't help but laugh at all this. It's just it's ridiculous. If the court grants the pending 12B1 motion, thus dismissing the plaintiff's remaining claims, the defendant would ask for an order as contemplated in Rule 41A2, footnote 2, which provides that an action may be dismissed at the plaintiff's request by only by court order on terms that the court considers proper. The defendants proposed the following. Oh, you literally wrote an order, and you literally wrote an order. You literally wrote an order. You wrote a proposed order. I mean, not that I'm aware of, but I will check. I just okay. This is Bubbles' proposed order. In light of a dismissal of the plaintiff's actions founded on diversity jurisdiction grounds, sorry, if you know, you know, and B, the prejudice to the plaintiff of being required to pursue counterclaims in this action, despite having not intended to do so, unless the plaintiff's claims were not dismissed, the court hereby orders that defendant's counterclaims are dismissed without prejudice under Rule 41, Federal Rules of Civil Procedure 41A2. Footnote 2. I'm wondering what the judge will think when he sees a proposed order in a motion from an attorney. I'm just... sorry, I'll have to look back at what even was said. The chat, I love you guys, but I'm like, nothing is... That's what it sounds like. He's like, here, I wrote an order for you. He said, this is a proposed order. Like, I just can't. Have a great night. Support judge. Oh my God. Hey, Patrick. Who the asshole think he's ordering a judge? Oh my God. No, this is not a new order. This was written. This is Bubbles' proposed order. He said, on terms that the court considers, the defendants propose the following. Bubbles wrote this, yes. Or someone acting as Bubbles. Footnote 2, the defendants cannot dismiss count 2 counterclaim under 41A1A1 because to do so would operate as an adjunction on the merits since the claim under Florida Statute 540.08 was previously filed in state court and voluntarily withdrawn under Florida Rule 1.420A1 to be pursued in federal court. Request dismissal under 41A2 is necessary because the plaintiff's counsel did not respond to a request to stipulate should the 12B1 motion be granted on the plaintiff's action to dismissal of the counterclaims without prejudice under Rule 41A1, capital A2. Further demonstrating the plaintiff's aim of protracting litigation and multiplying proceedings. I'm going to check just to see if the judge put anything in. Hey, beautiful. Oh, sorry. Hold on. There you go. We are just going to, when you think it can't get any more ridiculous, it does. Like, I just can't. Like, it just gets more ridiculous. Yeah, he can write footnotes, but he can't read them. Like, sounds that way. In Bubbles' defense, it didn't sound like he was telling the judge what to do. He is telling the judge what he thinks he should do. Not, hey, you have to do this. It's, I think that this would be a good idea. So, like, it's one of those things. Do I think he was telling the judge 100% what to do? No. However, it's the state case has not been this right here too. The state case has not been dismissed yet since sanctioning actions are to be held. There's a the the hearing that was supposed to be on the 5th got moved to April 16th, which I think is another Wednesday. Bubbles losing his marbles. I mean, this is just insane. So I am going to check to see if there's anything new. ID 10T. Yeah. I just can't. I don't understand the logic with this. Like, I just can't. I just can't. Oh, hold on. That was yeah. Okay. Never mind. That's what I already had. Max just sent it to me this time. I just can't. Does he seriously think that he I just the entitlement. The entitlement is off the charts. Like, yeah, he needs to write a book, How to Piss Off a Judge. Not to give him ideas, but he might be able to make some money off of that, because you can't make this shit up. Like, I could not write a story like this. You can't make this shit up. Like, that you can't make this shit up. So this is this is what we have. So yeah, that's that was today. So I don't know, but there is some issue. She's clapping. She's got her song on, and she's, yeah. The days of our YouTube dramas. Like, I can't. I'm sorry, for the first time in probably ever in this case, I'm literally speechless. It's one of the things where you just sit back and you go, this shit cannot be real. And Tony 2A, thank you for the 5 Squid Pro Quo memberships. It's like, I appreciate you guys so much, and I promise I got to do more members content. It's finding enough hours in a day. Like, I'm literally, I'm not to steal Tug's phrase, but like drowning in content. I started reading the FAA lawsuit with the air traffic controllers suing the Department of Transportation. That lawsuit is from 2015, but it's still not settled or gone to court yet. Tomorrow, Rosalind Duke and I are continuing to read the new Ruby Frankie lawsuit. There's the CNN defamation trial on Wednesdays. Thursdays, Thursday nights, I used to do a politics stream, which turned into Let's Expose Government Corruption. But so much is being exposed. I exposed, you said before, Elon. Because I was talking about that $6 million in Egypt last year. But, and then Thursday afternoon is meeting with Captain Kern and going over the documents in his daughter's case, which I'm going to have to move because our closing date for our house is Thursday, not Friday now. So I'm going to have to see if I can move that to Friday. I have to talk to him about that. It literally just happened like now. So it's just been this whirlwind of, it's just been a whirlwind of stuff. Like, and there's a new case well, it's not a new case. It's new to me. Back in October in Orange County, Florida, which is Orlando, the same county that Sarah Boone was in, there is a deputy a former Orange County Sheriff's deputy who is on trial for first-degree unaliving of his wife, who also worked for the Orange County Sheriff, after being under investigation for having some smexy time on the job with someone who was not his wife. So it's there's that. I'm working on getting the documents from that too. Orange County is, I'm going to show y'all how easy Orange County is. Orange County is probably the easiest county. Tiffany Moore Russell is the county clerk, and her website is super easy to navigate. Literally, this is it. I type in the name and the open criminal felony. This is how easy Orange County's website is. Orange County is the premier yeah. So this is all the stuff from last year, and there is stuff, waiver of speedy trial. There's supposed to be a hearing Monday, so I will be going through a stream on all of this. We started looking into this when we were doing a jury, or waiting for the jury to come back with a verdict in Colin Griffith's case. And this was brought to my attention. And anytime I can expose law enforcement who effed up, I'm happy to. Because, law enforcement and judges and attorneys should be held to a higher level of scrutiny because of the ethics they are supposed to abide by. So, yeah, Levy County wants to hide all this mess. This is Orange County, and they are the most open and easy county to find. So he's charged with first-degree unaliving with a firearm, and tampering or fabricating physical evidence. He staged it to look like a suicide, according to prosecutors. Allegedly staged it to look like a suicide. So, his Bubbles, the house husband. I wouldn't doubt it. And Patrick W., thank you for the $2 super chat. Popping bubble news. BBB is a pro hack. Allegedly. Just. Oh my goodness. This is just, when you think it can't get any weirder, it does. It does. But that is all I got for you guys. I have to go get her some dinner. See if the Mr. Squid is hungry when he gets home. Sometimes he's hungry, sometimes he's not. So I text him. Generally, I text him and say, hey, are you hungry? So I know whether to make a full meal or just something for her. So it's not alleged. Hey, Yamaha. I'm sorry I didn't say hi to you earlier. You have the Sonia Massey case coming up soon. I know very little to nothing about that case. So on that note, thanks all 566 of y'all for joining me. This is just when you think it can't get any weirder. Here we are. Starting at the beginning. Oh, good luck. It's gonna be interesting. Let's see if there's anybody to redirect you guys to, or if I let you go. Mo in the Deep End is still doing day 2 of Tennessee versus Megan Boswell. We're gonna redirect over to her. Tell her I said hi. Forewarning, trigger warning, that does involve a child. So if you are sensitive to those kind of things, I'm sorry. But Mo tries to do her best to make a terrible situation into an enjoyable experience. This one, 3 steps. And sorry, the chat's moving kind of fast. An officer in Volusia County was just bagged for stalking and misuse of government intellectual property last week. Planted GPS on ex-girlfriend's vehicle, following her around for months. I got to write that down, because that sounds like something to look into. Because I don't love when law enforcement is bad. Law enforcement is supposed to be the people who you look for protection from things. However, when law enforcement screws up, I love to let everybody know. Just a fun thing I like to do. And since my notebook is over there, Volusia County. And am I saying that right? Volusia? All right. Y'all have a great day. Tell Mo that I said hello and that I love y'all. I'll be over there for a little bit, but mostly just lurking while I she's right here. Hey King Paco, how are you today? So this is just absolutely ridiculous, and it's like it's as ridiculous as a soap opera. That's all I can say. It's ridiculous. Oh yes, please do. I love those kind of cases because it's one of those things of cops are supposed to be held to a higher standard, and there is a contention about this in this country where it's like one bad apple spoils the bunch, but we need to detach ourselves from support people when they need to be supported, but also call out the bullshit when you see it. And that's my mentality for life. Like, call out the BS, support who you need to support, but when they F up, don't be afraid to admit that they fucked up. And that's the interesting part. All right, y'all have a great day. Tell Mo I said hi and that I love her. Bye, guys.